19. The procedure of the court. The procedures of the court have been discussed in part in studying the laws of witnessing and of evidence. Other aspects of court procedure which are of particular note are, first, the place of the court, at the city gates. Deuteronomy chapter 21, verse 19, chapter 22, verse 15, chapter 25, verse 7, Amos chapter 5, verse 12 and verse 15, Zechariah chapter 8, verse 16, or on cases of appeal to the highest courts at the porch of judgment at the king's palace, 1 Kings chapter 7, verse 7. Symbolically, justice was thus the gate of the city. Symbolically, too, justice, having nothing to hide and everything to gain by being public, was totally open. The hearings of the courts were available to all. The concept of a public trial, as against the secret trial so common to antiquity and to tyrannies, was thus basic to biblical law. The public execution was part of this same principle. Secret or closed executions promoted in the name of dignity are, in reality, a sign of growing statism and incipient tyranny. Ultimately, in a tyrant state, the deaths are not only in secret, but are not even reported. In countries where weather does not permit public outdoor trials, indoor trials became only logical, but the principle of a public hearing must be retained. Second, we must not assume, as humanistic scholarship would lead us to, that trials in biblical eras were primitive and unrecorded. Long before Moses, written records were mandatory. Job, whose time is the patriarchal age, mentions in passing the court procedures of his day. "Oh, that I had one to hear me! Lo, here is my signature! Let the Almighty answer me! And that I had the indictments which mine adversary hath written." Job chapter 31, verse 35, ARV. Written charges and records were thus an early aspect of court procedure in order to fix the fine points of evidence and testimony. Third, contempt of court was forbidden, Exodus chapter 22, verse 28, and, where involving a radical rejection of the court's authority, was punishable by death. Deuteronomy chapter 17, verses 12 to 13. Fourth, witnesses had to take an oath before testifying, Exodus chapter 22, verses 10 and 11. The oath was a conditional curse, with specified penalties for violation, Leviticus chapter 6, verses 1 to 7. Fifth, cases could be appealed to the highest court of the land, to Moses, the judges of the nation, or to the king. 1 Kings chapter 3, verse 9. Indeed, the most important function of the chief magistrate or authority in a nation was, in biblical law, the duty to function as a final court of appeals. We cannot understand the greatness of Solomon and his reign without a recognition of this fact. The whole point of 1 Kings chapter 3, verses 5 to 15, is that the young King Solomon pleased God by desiring, above all else, to be a wise Chief Justice of Israel. He asked for understanding to discern justice, 1 Kings chapter 3, verse 11, ARV. It is a commentary on our times that Solomon is best known to us for his harem. In his age, it was ability as the supreme judge of the nation which gained him the greatest renown. His request of God was precisely this. Give therefore thy servant an understanding heart to judge thy people, that I may discern between good and bad, for who is able to judge this thy so great a people? 1 Kings chapter 3, verse 9. Trained by the prophet Nathan, a champion of the law, Solomon's major concern was the law, which was the cornerstone of the greatness of his reign. When men today think of Solomon's, quote, wisdom, end quote, they modernize the concept into something abstract, academic, and intellectualistic. The biblical reference to Solomon's wisdom means, most centrally, his wisdom as a judge, the wisdom he prayed for, and secondarily, his wisdom in administration. The Proverbs of Solomon are essentially a practical commentary on the law, and this is their wisdom. Solomon, by providing a godly and practical wisdom as judge in all cases appearing before him, ensured thereby that the final court of appeals in Israel would be a court of justice. The result was a great confidence among the peoples and a prosperity under conditions of justice. Solomon's later folly never entirely undercut the basic justice of his reign. Sixth, although arrests could be made on the Sabbath, Numbers chapter 15 verses 32 to 36, trials were held only during other days of the week. In American law, an offender may not be tried and convicted on Sunday, although he may be arrested, committed, or discharged by the magistrate. Seventh, the right to a speedy trial, to justice without delay, was not only a feature of the public hearings of the court, but also stressed as an instrument of sound administration by Artaxerxes in his orders to Ezra. And whosoever will not do the law of thy God and the law of the king, let judgment be executed speedily upon him, whether it be unto death, or to banishment, or to confiscation of goods, or to imprisonment. Ezra chapter 7, verse 26. This order brought together Persian authority and law with Hebrew law and tradition. This Persian order, cited also in the Apocrypha, 1 Esdras chapter 8, verse 24, is of particular interest in that it cites a form of judgment alien to biblical law, that is, imprisonment. It remained alien, although used by the Herodians. The imprisonment of men like John the Baptist was, in essence, an illegal act. Eighth, since in biblical law the function of the state is to be the ministry of justice, the highest office in the state was inseparable from justice and the courts. Administration, now most closely associated with the highest office in a state, was then a function reserved to officers of the king, members of the harem, eunuchs, and others. The basic function of the chief officers of the land, whether a judge in the earlier era or a king later, were twofold: to be the military leader and to be the chief justice of the country. The military office was not a constant one. It could be delegated to others, as in David's case, to Joab. The office of Chief Justice was a continuous one, and most basic to the state. This function of the king was common to medieval monarchs, and the success or failure of an English king, for example, very commonly depended largely on his abilities as the supreme judge of the nation. The very name for the king's audiences and his associates reflects this function: court and courtier. The king's court was originally not a showplace nor a centre of social functions, but a seat of justice. When kings' courts began to change into ladies' promenades, monarchy was in process of rendering itself obsolete. In any civil governments where administrative offices gain centrality, a growth of centralized power becomes inescapable because not justice to the people, but government over the people becomes basic to the nation and the state. Prior to Lincoln, American presidents were not as central to American life as they have since become, and the growth of presidential power has been a necessary result of the growth of importance of administration over justice. Prior to Lincoln, presidents in the United States tended to regard themselves as a variety of judges, and vetoes were based on legal considerations, on questions of constitutionality, and the presidential office was seen as an agency of judicial review over the acts of Congress. Much of the early uncertainty over the role of the U.S. Supreme Court was due to the fact that the historical background saw the Chief Magistrate as the final court of appeal over the justices of courts. The presidential power of pardon is a survival of this fact. Questions of constitutionality were at first raised by President Washington, only much later by the court. Appeals to the president to right wrongs long continued in American history as an echo of his undefined role as Supreme Justice of the American system. The administrative role took precedence finally, and a different kind of America began to take shape. In the Old Testament, Moses was the Chief Justice of Israel, a judge. The tribal leaders were various administrative heads of the nation. Their, quote, federal union, end quote, under Moses and Joshua was essentially military and judicial. They were under one law, and Moses was the Chief Justice of that federal union, as well as its supreme commander. The military functions Moses delegated to Joshua. The legal responsibilities Moses himself discharged. Samuel, as Chief Justice, made a circuit of the entire country annually. 1 Samuel chapter 7, verses 16 and 17, to bring justice to the people, to ensure their right of appeal by making appeal immediately available. Ninth, and finally, the judge was not to be an impartial referee, but a partisan champion of the law of God, actively concerned with bringing God's justice to bear on every situation. By requiring the wicked, by recompensing his way upon his own head, and by justifying the righteous, by giving him according to his righteousness. 2 Chronicles chapter 6, verse 23.